What do
With
you want
that,
this court to do?
I want the court to reverse the decision of the trial court below, which denied the preliminary injunction. Thank you.
Okay, thank you. And you have your 5 minutes.
Thanks.
Thank you, and may it please the court. My name is Peter Amuso, and I represent the Bucks County Community College. And I want to begin on Judge Covey's last question. This is a case where you're looking at a project labor agreement decision in your appellate jurisdiction. And of course, as you know, you cannot overturn a trial court's decision to deny a preliminary injunction if there is any reasonable grounds to do so on the record before that trial judge. And in this case, we did have a full evidentiary hearing before the trial judge. We presented 2 witnesses, opposing counsel presented 2 witnesses, and the trial judge did find that there was an urgent matter here. This is just like the Pickett case. This $2 million grant to the Bucks County Community College is just as important as the new convention center was to Luzerne County.
How can the trial court look at an urgency when it was the school that delayed? By the time they began taking bids was the date they were supposed to be starting construction or well underway.
I appreciate that, Your Honor. As other opposing counsel said, and I agree, this grant did not have this lab in it. This grant is $2 million to provide a certain educational program. And so when they got the grant, in fact, there was testimony, they got the grant in September of 2024. They actually realized that they needed to build a facility to provide the training in time under the grant. So they started meeting with the architect in August of 2024. There was lots of testimony in front of the trial judge, which he credited that they were working very hard to meet the timelines of this grant. They met with architects. They had to design the building. And this building is not big, and it is not as expensive as these other buildings, but it's technically complex because what they're doing is they are teaching people how to use these different systems. And so in a normal building, even in a large chemical laboratory building, you have air conditioning in traditional areas and jets in other areas. Here, it's all together. So this was a very complex building that they worked very hard, the testimony before the trial judge, to meet these deadlines.
Is that it didn't appear that there were extraordinary circumstances at the time a blanket PLA was issued, and that it lasts for 5 years. I mean, that's very unusual because it's open-ended in that there's really nothing in there because it's blanket, and then it lasts for 5 years. And typically you're coming in and saying, hey, we have urgent circumstances and ABC is Y, and it's not for a 5-year period.
Thank you, Your Honor. As again, opposing counsel made clear in the lower court hearing, this is not an attack on the blanket nature of the PLA. I agree with Your Honor, and it's certainly not the college's position that you can simply issue a PLA and have it exist for 5 years and you're going to use it on every project. On the record before the trial court, the PLAs from 2023, but they did show urgent circumstances in this case in the face of the timeline of an outside force. And this is not an attack on the blanket nature, but again, we're not taking the position that you can simply have a blanket PLA. You have to apply the circumstances and the analysis to each project, which the college did here.
And you still had to show that there was a need for workers, and I didn't see that in the record.
Well, Your Honor, I understand the 3-part test of the decision over the summer, but in the cases before this court, there's no 1 or 2 or 3 things that you have to show. You just simply have to show extraordinary circumstances. And certainly in Pickett and Sosong, the main focus was the timeliness, the outside deadline that was the problem. And we again, I cannot emphasize how important this $2 million grant is to this tiny Bucks County Community College, particularly in this funding environment. They need to meet these deadlines. And again, the trial judge had a reasonable basis to find there was those extraordinary circumstances.
Well, isn't a PLA by its very nature discriminatory? And that's why the test has been put into place that you have to show the 3 different factors?
There's no doubt, Your Honor, that a PLA is easier for union contractors to use. It does not exclude, and this is another finding by the trial court, that this PLA in particular is clear that it does not discriminate against somebody's union status for hiring. But you're right, Your Honor, a PLA is something that's different. It's something that's regularly recognized by this court, but in order to use the PLA, you have to show extraordinary circumstances. And this trial judge found that there was extraordinary circumstances given the urgency of this project.
And counsel, could you tell me what your name is, please?
Certainly, it's Peter, and my last name is Amuso.
Okay, and did you file a notice of appearance?
I did, very candidly, I believe it was just on Monday, Your Honor.
Okay. And you probably understand why I'm asking that, which is that you were not on the brief.
Correct, Your Honor.
I'd just like to tell you that what has, in my mind, what has happened here is
Yes.
absolutely inexcusable.
I understand, Your Honor. Would you like me to talk about that, Your Honor?
If you wouldn't mind, please.
I do not mind at all. And so as opposing counsel properly pointed out in his reply brief, an attorney working for my firm apparently used artificial intelligence to file her brief before you. And she only notified myself and my colleagues late Thursday afternoon, and so we have sought to file an amended brief.
But wasn't one of your partners also listed on that brief?
He was not listed on the brief, Your Honor. He was entered
Entered an appearance in the
of
case.
this case.
And what responsibility is there on a person who's entered an appearance in a case or who is in charge of a firm?
Your Honor, there's a tremendous amount of responsibility, and we are in the process of taking actions to make sure this never happens again. We've already issued an internal policy. We're reviewing everything that this attorney has done. I assure you, our managing partner has been focused on nothing but this since we first got the notice. My colleague who did this, she is an incredibly well-respected attorney in our county. She has a long history of service to our country. In this case, both in front of the trial judge and before Judge Wojcik, she aptly handled herself. She filed briefs without any of the issues to which you're referring to, and she was handling this case very well. I apologize to the court that this happened. I've already had a previous conversation with opposing counsel, and we are prepared to take whatever steps we need to, that any agency decides that we need to, and we'll cooperate fully. And again, are continuing our internal
Well,
review
but
of what
you said
happened.
that you would take steps that an agency decided that you needed to take, but you already know proactively of steps that you might need to take without us telling you, as far as ethics.
Understood, Your Honor. And again, we're in the process of reviewing what happened. And my colleague, where this happened, she's currently on medical leave, and we have not been able to talk to her directly, but we will take those steps proactively, Your Honor.
It's a good case as an example to firms that they should be implementing AI policies right now while it's already available, not after the horse is out of the barn.
Completely agree, Your Honor. It's something that was under review at our firm, and now we've issued that policy.
Is there any basis to allow us to grant you an opportunity to amend the brief?
Your Honor, simply to resolve this case on the merits. This case has been fully briefed and litigated both at the trial level and before Judge Wojcik. We have no interest, and I appreciate opposing counsels recognizing this, to mislead the court in any way. And for that reason, we wanted to present the court with a brief that did not have these AI issues in it. And again, we do apologize for it. I'm happy to talk about that further, or I see about I have 5 minutes left. I mean, again, I think this is a case where We've argued these same issues in front of the trial judge, in front of Judge Wojcik. There's nothing new here. Again, I would submit to the court, this is Pickett 2.0. This is an agency that's faced with outside deadlines that are not under their control, that are absolutely critical to
You
the...
keep saying there's deadlines. I don't understand. I mean, the college sat for 10 months. They didn't act on anything.
I appreciate your position, Your Honor, but I think the record before the trial court does not show they sat on their hands. It shows they were actively trying to design this building that's a very unusual building with the architect. And in fact, they started that process even before they got the grant. So once they realized, look, we might get this grant, and in order to provide the training that this grant pays for, we need to have a specialized facility. So again, the record before the trial judge, which he credited, they were not sitting on their hands. They were working very hard to get the thing designed so then they could get the specs that they could put those out to bid.
Counsel, you said that they didn't know, the college didn't know that they would need a building, but wouldn't that have been involved in the whole grant process or the grant that they responded to?
There was, I apologize, Your Honor. There was testimony that I think originally they thought that another facility that they already had would be useful, and then they realized either right around the time they were getting the grant or right before that, oh wait, that facility is not going to work, which is hence the intense deadline that they had in order to meet these extraordinary circumstances. But again, I just remind you that you are looking at the trial judge's decision, and if there's any basis on which he could have denied the preliminary injunction, you should affirm that denial. And again, I think there was any reasonable basis for him to deny the injunction. There's extraordinary circumstances here. The trial judge found that, and if you have no further questions, I appreciate your time today. Thank you.
Thank you, Your Honors. I want to address a couple of the issues that were just raised. First, and I don't want to dwell on the artificial intelligence, but we opposed the application that the community college filed to submit a revised brief. I think they filed it last week. It's just fundamentally unfair. We didn't see that, have a chance to address any of the arguments in our reply. And it's not just a revised brief that takes out the hallucinations in the first brief. They are citing new cases that they didn't cite in the first brief. They include additional arguments and a whole chart comparing PLAs, all new and different things that it really just defeats the fundamental fairness of giving us, as the appellant, a reply if you allow that amended brief. So we believe that the remedy is that they should not be allowed to file the new brief. And we also believe, because of the severity of and sort of the pervasiveness of the hallucinations in that first brief and we took the time to go through, of the 16 cases cited or citations, 9 of them were either just fake cases or misquotes and complete misrepresentations. If it was 1 or 2, you could say...
Can I get to the merits?
Sure.
I appreciate everything you're saying.
Okay.
But counsel's arguing that if there's any basis, that he said that repeatedly. Do you agree with that being the standard?
No, the standard is the college has to show that there are extraordinary circumstances, because PLAs or project labor agreements are disfavored because they are discriminatory on their face. They can only be used.
That's the appellate standard?
That's the appellate standard for reviewing the preliminary injunction is abuse of discretion in this case.
Do you disagree with the standard? I thank you, Judge Wojcik, for following up on that.
You disagree with the standard?
Do I disagree with
Yes.
the abuse of discretion standard?
No, that if we find any reasonable basis to uphold the lower court, we must.
Under the lower court decision, Judge Yeager's decision, is the question is whether or not he abused his discretion in denying the application of the motion for preliminary injunction. And if the court finds that he abused that discretion, that would dictate the court's outcome.
Opposing counsel is saying that our standard of review puts us in a corner because it is so narrow that if there's any reasonable basis, we're bound to affirm. And so I'm wondering if your position is it can't be reasonable to commit an error of law.
It can't be reasonable to commit an error of law. I would agree with that. And when we look at the lower court's decision, it was, we believe, there were several errors of law. The first is finding extraordinary circumstances where none exist. And the second was the lower court's review of the certain provisions in the project labor agreement and saying that it wasn't discriminatory on its face, looking at the hiring hall provision and the management rights provision in the project labor agreement and saying that somehow that project labor agreement wasn't discriminatory. And the fact that the trial court kept on going back to was that the project labor agreement didn't absolutely bar non-union contractors from bidding on the project. But this court, in an en banc decision, the Alan Myers decision, made clear that a project labor agreement, to be considered unlawful and discriminatory, doesn't have to bar non-union contractors from participating altogether. The question is whether or not the non-union contractor and the union contractor are on equal footing. And clearly, there is no equal footing here because the non-union contractor can't use its experienced workforce. It has to surrender that right if it's going to sign the project labor agreement and use a labor force that it's completely unfamiliar with.
Don't we review the trial court's decision based on whether it applied the correct rule of law? And then if it did apply the correct rule of law, whether it applied it correctly based on the facts?
That's an accurate.
That's how we look at this case.
That's correct.
And you're saying
Judge.
the trial court erred because it didn't consider the three factors for extraordinary circumstances.
Correct. The trial court did not consider, as a matter of law, the three factors for extraordinary circumstances, and the trial court made an error as a matter of law when it found that there's something special about this project labor agreement, that it wasn't discriminatory, when it clearly is discriminatory because, again, the non-union contracting community is not on equal footing when participating in this project. Thank you very much.
Thank you very much.